Hello, friends. If you own a home, have money in a bank account, or have a retirement account with your name on it, what I'm about to tell you is one of the most important things you will hear this year. Right now, tonight, there are legal mechanisms in place that could take everything you have spent your life building away from your family after you are gone. Not because of fraud, not because of a scam, but because of how the American legal system actually works. Most people only find out after it is too late to do anything about it. Today, I am going through every single trap, the exact form or action that prevents each one, and what you need to do before the end of this week. Before we get into it, subscribe to this channel right now and turn on the bell. This is exactly the kind of information that most people never hear until they are standing at a bank counter after a death being told they cannot access a cent. Subscribe now and let's get into it. Let's start with the one that affects every single person watching this who has a bank account, which is everyone. If you die without a named beneficiary on your bank account, that account does not go to your family, it goes to your estate. The moment it goes to your estate, a court process called probate opens automatically. Most people assume their will handles this. It does not. A will is a letter of instruction addressed to a probate judge. It carries zero legal weight at a bank counter. The bank's obligation runs to the contract on file, the account agreement you signed when you opened the account. If that contract names no beneficiary, the bank has no legal authority to release a single dollar to your family, regardless of what your will says, regardless of the relationship. Here is what probate actually looks like in practice. In most states, there is a mandatory creditor waiting period built into probate law, typically 3 to 6 months, during which unknown creditors, medical providers, credit card companies, and anyone who might have a claim against the estate must be given time to come forward. Your family cannot receive a dollar until that window closes. The court moves on the court's schedule, not your family's. Filing fees, publication fees required by state law, executor bond premiums, and probate attorney fees, which in many states are calculated as a percentage of the gross estate, can easily consume $10,000 to $15,000 or more before a single dollar reaches your family. The entire process in a contested or complex estate can take 1 to 2 years. The form that prevents all of this costs nothing and takes 10 minutes. It is called a Payable on Death Designation, or POD. Every FDIC-insured bank in the country is required to offer it. You go to your bank in person or through your online portal, ask for the POD Beneficiary Designation form, name your beneficiary with their full legal name and social security number, and submit it. When you pass, your beneficiary presents a death certificate. The bank verifies the designation, and the transfer processes in days, not months, with no attorney, no filing fees, no mandatory waiting period, and no court involved. Before you move on from this topic, understand 3 critical things. Each account requires its own separate POD designation. One form does not cover all your accounts. Your checking account, savings account, and each certificate of deposit are separate contracts requiring separate designations. Also, brokerage accounts use a different form called a Transfer on Death Designation, or TOD, filed with your brokerage firm, not your bank. If you hold stocks, bonds, or mutual funds in a taxable brokerage account with no TOD on file, those assets go through probate exactly like an undesignated bank account. Finally, name a contingent beneficiary as a backup. If your primary beneficiary dies before you and no contingent is named, the account defaults to your estate and probate opens again. The second trap affects every homeowner, and it involves the single largest asset most seniors own. Your home, if it is titled only in your name and has no specific transfer mechanism in place, goes through probate when you die. The house is frozen. Your family cannot sell it, rent it, or access any equity in it until the probate process concludes. In many states, that process takes 6 months to over a year. In the meantime, the mortgage still needs to be paid, the property taxes still come due, the insurance must be maintained, and any maintenance issues still need to be addressed, all while your family waits for the court to give them legal authority over the property. There are several mechanisms that transfer a home outside of probate. The simplest is joint tenancy with right of survivorship. If your home is titled in both your name and another person's name as joint tenants with right of survivorship, the property transfers automatically to the surviving owner when you die. But joint tenancy means the other person is a co-owner right now, which carries risks if they have debts or go through a divorce. A better option in many situations is a transfer on death deed, available in more than 30 states as of 2026. A TOD deed names your beneficiary directly on the deed. While you are alive, the beneficiary has zero ownership rights. When you pass, the property transfers automatically by recording the death certificate with your county recorder. No probate, no court, no waiting period. Recording the deed costs $20 to $50 in most counties. It is one of the most powerful and most underused estate planning tools available. Check whether your state offers it. The third trap specifically targets seniors who receive or may need Medicaid long-term care and involves a law most people never hear of until a letter arrives from the state after a parent's death. Federal law requires every state to operate a Medicaid estate recovery program. If you receive Medicaid-funded long-term care after age 55, including nursing home care, home health services, or related costs, your state is legally required to seek reimbursement from your estate after your death. The most common asset states pursue is the family home, because by the time most people qualify for Medicaid, it is typically the only significant asset left. Nursing home care now averages approximately $119,000 per year. A 2 or 3 year stay generates a $200,000 to $350,000 Medicaid claim against your estate. After you pass, your state sends a letter to your family demanding repayment. In most cases, the only way to satisfy that claim is to sell the house. Important protections exist. The state cannot pursue recovery while a surviving spouse lives in the home, while a disabled or blind child lives there, or while a child under 21 is present. An adult child who lived in your home for at least 2 years before your nursing home admission and provided care that delayed institutionalization is also protected. The critical issue is timing. Federal law prohibits transferring assets, including your home, within 5 years of applying for Medicaid. This is the 5-year look-back period. If you transfer your home to your children within 5 years of needing Medicaid, you face a penalty period during which Medicaid will not cover your care. Planning must happen 5 years or more before you might need long-term care. An irrevocable Medicaid asset protection trust created at least 5 years in advance is the most common legal tool. If you believe you or a spouse may need long-term care within the next decade, speaking with an elder law attorney now is one of the most financially important conversations you can have. The fourth trap catches people who believe they have already handled their estate planning, but whose beneficiary designations have not been updated in years or decades. Your retirement accounts, your IRA, your 401k, your 403b already operate on a transfer on death principle by design under federal law. They do not go through probate, they transfer directly to whoever is named as beneficiary on the account. And that is precisely where the trap is. Under federal law, specifically the Supreme Court's ruling in Egelhoff versus Egelhoff, the named beneficiary designation on a retirement account controls over any conflicting will, divorce decree, or court order. If your ex-spouse is still named as beneficiary on an IRA you opened in 1998, your ex-spouse receives that money regardless of your current will, regardless of your divorce settlement, regardless of the relationship you have today. Courts have ruled against surviving spouses, adult children, and estates in case after case because the beneficiary form controls, not the will. This is not a theoretical risk. Retirement accounts represent the largest portion of wealth for many American families. An outdated beneficiary designation on a $400,000 IRA directs $400,000 to the wrong person with no legal recourse for your actual family. Log into every retirement account you hold, your IRA custodian, your 401k plan administrator, your pension if it has a beneficiary option, and verify that the person named is who you actually want to receive that money today. Update any outdated designations immediately. Do it this week, not when you think about it again. The fifth trap is one that catches people by surprise because it involves something that feels completely secure: a safe deposit box. Many seniors store their will, property deeds, financial account information, and valuable documents inside a safe deposit box at their bank and give a spare key to a family member believing that gives them access. It does not. Federal banking regulations require banks to seal safe deposit boxes upon notification of a customer's death. Your family will be denied access even if they have a key and even if they have a notarized will in their hand. If the will itself is inside the box, the family faces a circular problem. They need the will to open the probate case, but they need a probate order to access the box. The solution takes 5 minutes and costs nothing beyond the standard rental fee. Go to your bank branch and add your adult child or another trusted person as a joint renter on the safe deposit box contract. Both of you sign together. They retain complete access to the box regardless of what happens to you, independent of the probate process and independent of any other legal proceedings. So here is your complete action list for this week. Go to your bank and file a payable on death beneficiary designation on every account, checking, savings, and each CD separately. If you have a brokerage account, contact your brokerage firm and file a transfer on death designation. Check your state's laws to see if a transfer on death deed is available for your home, and if so, consider filing one with your county recorder. If you or a spouse might need long-term care within the next decade, consult an elder law attorney now about Medicaid planning before the 5-year look-back window becomes an issue. Log into every retirement account you own and verify that the beneficiary named is who you actually want to receive that money today, and update any outdated designations immediately. And add a trusted family member as joint renter on any safe deposit box you use for important documents. None of this requires an attorney for the basic steps. None of the forms cost anything. Every one of them can be started this week, and every one of them protects something that took a lifetime to build. Subscribe, share this with every person you know who owns a home or has a bank account, and I'll see you in the next one.